Negro and members of the committee. My name is Ilya Shapiro. I'm a senior fellow in constitutional studies at the Cato Institute. I'm not an expert on the intricacies of the model legislation that you will have Mr. Dranius testify on, but I will be talking about legal and constitutional issues attending the idea of this prosperity zone compact method for achieving the reform that Mr. Clancy just talked about, that Nick will talk about. Like Eric, I'm a naturalized U.S. citizen, actually. I was born in Russia and came by way of Canada, so I liked immigrating so much I had to do it again. And like most immigrants, Eric and I do a job that native-born Americans won't necessarily. In my case, that's defending the Constitution. I'm also, I should say, a member of the Council of the Compact for America's Council of Scholars. And because of that, I'm an ardent supporter of the compact approach for reform. I think historically it's been underutilized. There are more than 200 interstate compacts around the country. You probably haven't heard of most of them, but when I tell you that there are things like the Port Authority of New York and New Jersey, you'll say, oh, right, all of those kinds of things when states need to share water resources, say, or for that matter, just law enforcement cooperation. Those happen daily, right, where law enforcement officials from different states cooperate. Those are all the results of these interstate compacts. The average state is, in fact, party to at least 25. I haven't looked up how many Arizona is part of, but I wouldn't be surprised if it was that many or more. They're very prevalent, especially in the western states. And their subject matter may involve any state power, whether it's over water resources or the border, whether it's coordinating policies among states for, say, interstate insurance product regulation or the qualifications of educational personnel, so teacher certifications can transfer across states, medical licensure, all of these sorts of things. And as with uniform laws on commercial transactions or trade secrets, virtually any public policy can be embedded in a compact, whether that's regulatory policy or economic development, whether it's transportation policy, coordinating tax law, or anything else. Even advancing constitutional amendments, another side project that Compact for America is involved in, is a balanced budget interstate compact. Once two states, at least, pass the same legislation to adopt this prosperity zone compact, then a sovereign contract is formed between them. And any state can join that as long as they agree to those terms. Senator Worsley, you asked about congressional consent. Congressional consent is needed where federal powers are implicated or invaded in some way. And so if two states agree to cooperate in terms of their law enforcement, if you're just talking about their state laws, then federal congressional consent nor federal law is unnecessary. The Compact Clause, which Article 1, Section 10, the Supreme Court has held repeatedly, sweeps no more broadly than the needed federal supremacy to defend federal prerogatives in the exercise of delegated federal power. So again, states can agree amongst themselves to enforce each other's rules in various ways, and as long as they can't say, oh, and the EPA has no jurisdiction here. They can't do that without congressional consent. But they can certainly do whatever, coordinate their own agencies however they like. And indeed, if a compact merely coordinates powers that states can exercise on their own without enhancing their authority relative to the federal government, then there's no need for congressional consent. As has been mentioned, there already is congressional consent over some of the terms that would no doubt be part of the compact, that is, those that can be construed as enabling cooperative effort and mutual assistance in the prevention of crime and the enforcement of their respective criminal laws. There's a standing congressional consent for all of those sorts of criminal justice and cooperation rules. So to the extent that prosperity zones would have a punitive regulatory component of some kind, Congress has already consented to that. And finally, upgrading the Prosperity Zone Compact has been mentioned. That means if congressional consent is given, then the compact would be upgraded to the status of a federal law. That's what the Supreme Court considers interstate compacts. Again, interstate compacts have their own are their own legal institutions with binding authority between and among the states. But if the if Congress consents to them, then they have the same standing as federal law itself. The only known possible limit on this upgrade is if it receives congressional consent over an area that's not an appropriate area for federal legislation. But then we're back to the state sovereign's idea. If the federal government doesn't have authority over a given thing in the first place, then the states can do it without that congressional consent. There are no independent constitutional impediments that I can see to treating the Prosperity Zone Compact as the equivalent of federal law when it receives congressional consent. And once it comes into being, this compact would be a fully legal institution, an enforceable contract among state sovereigns that could be upgraded to the status of federal law upon congressional consent. There are no constitutional reasons why the contemplated fiscal and regulatory reforms can't be achieved in this manner. And with more and more tension between states and the federal government and gridlock in Washington, as I said, this is a very innovative, entrepreneurial, I would say probably a leading 21st century way of achieving reform, of going around kind of the breakdown in national governance. So thanks for that. For that time, I welcome your questions.